Hello, hello, and thank you for joining us here on the Human Resource. I have brought back I don't want to say an old face. I am bringing back somebody who actually helped us through the pandemic. And the topic today is going to be on the difference between 1099s and W 2s, but with the new face, the new look with the new administration. Faith Whitaker from Dinsmore here in Cincinnati. She's the employment practice chair, group chair, and partner. Faith, thank you so much for agreeing to do this.
Thanks for having me, Pandy. I'm so happy to be back, and I am actually really glad we're not in the middle of a pandemic talking again.
Well, that's exactly right. At that time, we were kind of shooting from our hips. We were collaborating with what you knew, what I knew, what some of the other people that we work with knew, and trying to build a foundation by which to help employers through that topic. And now we've got all of these other topics and 1099 and W-2. This is a topic that never really, it's kind of gone into the shadows, but enough has changed that we really, really need to be reminded.
Absolutely, and it's interesting because this final rule came into place, changing really the factors of how we assess whether or not somebody is an employee or an independent contractor last March. So we say this and we have this podcast, but I will tell you that who knows what will happen in the next year or two if if these factors will change again. But it comes up often in my practice where it makes sense. A lot of times our clients are wanting to know, can we make this person an independent contractor, or is this person really a contractor? Should we hire them on? What's the difference? What do we need to look for? And so it is something that comes up, and I will say that it's, of course, what we always say in employment law, which is depends on the circumstances, right? It depends on the situation. So the final rule, I don't know if this would help just sort of launching into it,
Sure.
but it talks about these 6 factors, and I'll go through each one because they are a little bit different than it used to be. But one thing to note that I always really think about when I'm telling clients, okay, is this person really an employee or is this person really a contractor, is the amount of control. So if you think of the individual who's in their own sort of business, who's then just lending some services non-exclusively to that company, that is going to be more of an independent contractor versus somebody who is under the sort of the whims of the company, has to come at a certain time, only can work for that company. There's no duration set. Those are going to be your general kind of things to think about. That would be more of an employee. And before we even kind of get into this, you're probably thinking, and some of your listeners are thinking, why do we care? Why does it really even matter if somebody's an employee or an independent contractor? And the reason we care is for tax issues, certainly, which I'm not a tax lawyer, so I'm not going to go through the main reasons that it's tax implications, but certainly tax implications, but also from a wage and hour type of standpoint. Certainly the Department of Labor wants to know, and it's a matter of paying people correctly as well. So we don't want to just say, okay, these people are independent contractors, they get a flat rate of pay, and then potentially they should be classified as employees earning every single hour that they're working. And then we have an issue with overtime potentially. So that's why we even care about this as an employer. So the common themes that we look at is the exercise of independent judgment. So like I said, is this person can kind of come and go as he or she they please? What kind of judgment do they need to use for this job? The attempt at marketing themselves. Marketing was a sort of a more unique focus that hadn't come up before in the other standards. But does this person have the ability to market? Or is it really just they're relying on the company to market the services? A non-exclusive working relationship. I'll mention this again. This independent contractor can work with any other company. Now, there might be, of course, a confidentiality agreement that you would make sure that you want your contractors to have in place. They're not sharing your trade secrets to the extent that they have it, but usually you don't have a non-compete with an independent contractor because, again, that's going to be more of an employee because of their control. and then the ability to set their own schedule. So instead of, the client sets it's, yeah, I'm going to come in here and when I come and go. Now these again are just sort of common themes, because sometimes you will have a situation where the person's still a contractor, but they have to come at a certain time because that's when the work needs to be done. Again, everything is circumstantial, of course, in everything we do. Before I go on, Pandy, is there anything you want me to stop, or want to continue on with the factors?
No, I think you're on a roll here. I'm thrilled
Okay.
that you brought up the overtime aspect of it, because quite frankly, that's when most of the situations I've been involved in have come up, because someone has been working all these hours and all of a sudden they look around and go, wait a minute, I probably should have been getting overtime. And wait a minute, why am I not in a 401k? Why am I not getting employee benefits?
Yes, the benefits, exactly. And to me, that's all sort of the tax piece. But yes, you're right, benefits too. So that could be a whole other violation and penalties if we're not, complying with those things. Okay, so the new factors, there's 6 of them. The first one is opportunity for profit or loss depending on managerial skill. So this one's sort of, again, it's a new one that hadn't been articulated this way, but it's essentially, can this individual negotiate the pay, the pricing? Can this individual market themselves, or is that all at the whim of the company? And it's really, when you dig down into the new guidance, it's best practices is the more agency that the individual has, the more likely that they're actually a contractor versus an employee. Makes sense. So it goes to that control a little bit.
And stop there, because I want our listeners to think about this. Listen very closely to what she just said. How many of you are bringing in independent contractors and you're telling them what you're going to pay them, or you're telling them this is what you can expect, or record your hours and we'll pay you this amount an hour? That is not a negotiation. And I had one group who actually, I told them, I said, I want the price lists of all the independent contractors you're working with. I want to know what they're offering, the different services, and I want to see what they're offering in terms of you and every other client that they're working with. And they were taken back. Oh, we can't ask them that. Oh, I think they can, can't they, Faith?
And we should, because you're exactly right. That's such great advice. Because again, you're looking at it, is this individual sort of in a business entity of their own that they're servicing their work at? And do they market themselves? Do they price themselves? Do they do these things? If not, then if we're just setting the price and telling them when they can come in and who they can work with and what they do, that's an employee. That's the control that an independent contractor wouldn't have. So the next one is investment by the worker and potential employer. So I think this one is really, does the independent contractor rent their own space? Do they have their own software? Do they have their own computers? Do they have their own equipment? Now, again, just having, one or less of these. So in other words, maybe the independent contractor doesn't have their own space. That's not going to just completely negate their status. But when we're kind of looking at this, again, it's somebody that has their own business that they're then renting out their services essentially for that business, versus somebody who comes to the same building with the employees that are already there, working with the company's equipment, doesn't have their own marketing, doesn't have their own website, doesn't have any of that. That's going to be more an employee versus the contractor.
It's probably ill-placed, and you can talk about this a little bit further, but I even look at in terms of investment is, are they carrying their own insurance? Are they carrying general liability insurance, professional liability insurance? Are they carrying workers' comp? Remember, if these people are coming in and they are not on your payroll as W-2, they are not. If they get injured, what's going to happen if they don't have their own?
That's exactly right. And those are all the risks that come with it if we don't have it. I always tell the story because it's my best friend who wouldn't mind me telling this, but she started her own dog walking company a long time ago. Now it's very successful. But at first her accountant, I won't name names, kept telling her, you should make these dog walkers independent contractors. Or, again, she's starting a business. It's very expensive. And I said, best friend, not going to name her name. As soon as someone gets bit by a dog, you're going to be in big trouble.
That's a big one.
That's a big one, right? And sure enough, of course, about 9 months in or whatever it was, someone did get bit by a dog, and she did call me, and she said, thank you so much, because, workers' comp is handling it, and it's all good. And now she has a really successful business and doing really well with it. Still, this was years ago, even before this guidance came out, which was even more strict. But I always, reference that story. The dog bite's going to get you for sure. The other thing too on this topic, and you brought up, the insurance and making sure there's certain things. Of course, we want an agreement like that, but that's not even just having an agreement alone with a independent contractor doesn't mean, oh, for sure they're an independent contractor, but it certainly helps. So we definitely recommend putting together some kind of contract with the independent contractor that outlines, like, you are not an employee, you do not get benefits, you need to have your own insurance, you have to have your own space, you have to do this. But whatever it is, we of course can help draft those agreements. We do them all the time. But the more that we can, put in writing, it is another, I guess, piece of support to show that this person is an independent contractor versus an employee. Versus if you have nothing in place, then that's definitely harder to say, oh yeah, no, this is an independent contractor.
Well, let me jump in here, and I know we're running out of time, but I also want to say, ladies and gentlemen, please do not offer them a confidentiality statement that has the word employee used throughout the document. Please do not have them signing your employee handbook, because you want to make sure they know where to park and where the recyclables are. And I'm still finding companies that do this. So please make sure, and everybody's heard me say it over and over again, but there are certain documents that are legal documents. And this is one of the most important. An independent contractor agreement is not something you pull off the internet. It's not something you cut and paste from your previous lives. And I'm going to add to that, Faith, I tell my people I want them to have a statement of work so that it looks fractional. It is project based. So there is no long, unlimited time period. We're going to pay you this amount that we've negotiated for this project. And if we extend you and have you work on another project, we're going to have another statement of work.
That's really great advice. And that actually lends itself right into the next one,
Yay.
Which is the degree. It's great. The degree of permanence of the work relationship. So it should be definite in duration. Even if you don't really know, you can say, the project is anticipated to be 6 months. We will re-look at this upon 6 months, or whatever it is. Non-exclusive, project-based. I mean, that's what we want. We don't want just somebody who's working for, a company for 3 years doing the same thing. That, to me, is an employee, not an independent contractor. The other thing, too, is the ability to be able to turn down the work. So this is person in business, and if they don't have time because they're doing another project, that's going to lend itself to be, again, a non-exclusive relationship, which is great for classifying as an independent contractor. The fourth one is in nature and degree of control. I feel like that speaks for itself, and you kind of talked about it already, but it's really how the work is done. Can they control pricing? Can they have a say in marketing? How, that kind of control, which makes sense. The next one is extent to which the work performed is an integral part of the potential employer's business. Now, this is a new one.
Yeah, elaborate on that one.
Yes, I know. Wait, what? So the extent to which the work performed is an integral part of the potential employer's business. Now, if what this person, the independent contractor, is doing is the main thing that this employer does, then that's going to make it seem like that independent contractor is not one and more employee. They give an example from the DOL. This is sort of simplistic, but they talk about a farm, and they mainly just harvest tomatoes. So, of course, if we hire somebody to be a tomato picker, they're going to be an employee. Versus if they hire someone to do payroll just every once in a while or seasonally, they're not doing tomato picking. They don't really have anything to do specifically with tomatoes, so that's going to be an independent contractor. So it's a little different, though, I think. Skills and initiative is the last one. And I think that this is really talking about whether or not they have a business-like initiative. So they say that a couple times, business-like initiative, which I think goes to, can they market themselves? Do they have their own company? Do they even have their own website? Do they have, or they have an LLC, what those types of things, or are they really at the behest of the company when they're working?
Can I add
Those
in?
are the oh yeah, please.
Can I add? I always interpreted that part too to be that we're not hiring somebody that we have to train. Now maybe we're training them on proprietary software or equipment, but we're not training them to be an accountant, or we're not training them to be a graphic designer. They are who they are, and we're bringing them in because of that skill set.
That's exactly it. So the example from the DOL, again, I think these examples are helpful, at least picturing this, that they say a highly skilled welder provides a specialty welding service, such as custom aluminum
There you go.
welding
Yeah.
for a variety of area construction companies. The welder uses these skills for marketing purposes to generate new business, to obtain new work, and those facts show that that skill is sort of a separate business-like initiative that would make that person not an employee. So and all these, again, are a totality of circumstances. Not one is going to outweigh the other necessarily. It really depends on what's going on. Now, the case law is going to be, if you look at even recent years, it's really about the control and the duration of employment. I think those are the main ones that are going to classify folks as employees.
Faith, that is so important. And again, more companies than not have a 1099. They just kind of forget about them, and because the person's been there so long, they're I guess we are paying them differently. Two more words of warning. Please remember, listeners, no working interviews. You don't bring a new hire in as a 1099 just to see if they fit. That's not going to fit within her 6 initiatives here. And second of all, if you have any questions, please ask. Get a hold of Faith or your labor law attorney. Remember, not your tax attorney, your labor law attorney, and go over some of these points, because you don't want to be caught at the end and have to explain why. It's just trust me, I've seen a company go out of business for this. Faith, thank you so very, very much. How can they reach out to you?
I'm on Dinsmore Shohl's website, Faith Whitaker, and it's faith.whitaker@dinsmore.com if you want to email me. And I appreciate it so much, Pandy, and look forward to hopefully being on another show at another time with, I'm sure, what will be a very interesting season of employment law.
I am telling you that as with things changing, we're going to need people like you on the show much more often. Listeners, please send in your questions. That's why we're here. And we love helping you in every way possible here at the Human Resource.